on a podium of this height, as I mentioned yesterday when I was helping judge the debates. It's one of the few times when I get to feel tall. So I'm basking in that rare opportunity of feeling tall, so bear with me. My ego may also expand as I talk. Yesterday, I also had the pleasure of judging, along with Ms. Ghani and Ms. Williams-Paul, the high school mediation debates. And as the Honorable Chairman Gafur mentioned, if yesterday is any indication of the future potential of this beautiful country, then you can all breathe easier. I also noticed that the topic I am to speak about in the program above my name reads Mediation, a Pathway to Peace. That's a theme of the symposium, but the topic I am speaking about is a lot more prosaic. It isn't as noble as the concepts you just heard, unfortunately. Or maybe fortunately, you'll be the judge at the end. But it's a topic and a discussion on mediating medical malpractice cases. But I think I can safely say that if you have successfully mediated a medical malpractice case, then you are indeed on the pathway to peace. With that said, all protocols being observed, honored members of the judiciary, learned guests, and new friends, thank you for inviting me here to speak to your fifth annual mediation symposium. In all humility, I am truly honored. It's also an absolute pleasure to be here in this beautiful country. As a Canadian, it's tradition to complain about the weather. The saying goes, 50 weeks of winter and 2 weeks of lousy skiing. A few days ago, it was minus 18 degrees Celsius with the wind chill, and this is November, mid-November. So the temperature here is a lot more pleasant, to say the least. Although I understand it's warming up today. But I don't know, it will never reach the temperatures we're at today. So it's an understatement to say that it's a pleasure, as I said, to be here. But the temperature is exceeded, the pleasant temperature is exceeded by the warmth and hospitality of the people. I have been overwhelmed, truly overwhelmed, by the generosity and graciousness that I have experienced since I've arrived. I arrived here as a guest, but I believe I will be leaving here as a friend who can't wait to return. I also note that I am designated as the featured speaker. This designation will no doubt prove to be a valuable currency when I show it to my family, where I sometimes rank below the family pet. But truthfully, ladies and gentlemen, that is too lofty and honorific given the surrounding company. The topic today is mediating medical malpractice disputes. And before I start, some of my talk will be a bit repetitious to what you've heard before, because one of the disadvantages is none of the speakers get a chance to get together to discuss what they will be speaking about, so there's a bit of overlap. So bear with me, or during that period of time, if you're disinterested, text silently on your phone. Okay. So the topic today is mediating medical malpractice disputes. Those who practice in this area of the law know it's not for the faint of heart. From my experience, when I practiced law, taking on a medical malpractice lawsuit signified that a tough and expensive battle loomed ahead. The subject matter is complex and the law at times nuanced. Medical malpractice is a subset of negligence law. What distinguishes the traditional negligence claim from a medical malpractice claim is the relationship between the principal parties. The health provider and his and her client, the patient, are involved in the lawsuit because of some event that has breached their relationship. Emotions are high. The setting is where the patient placed his trust in the hands of a physician seeking his or her help and now feels betrayed and worse off. The doctor, on the other hand, feels his or her knowledge, expertise, reputation, efforts are being questioned and challenged. It all comes to a head in the form of a lawsuit, a medical malpractice lawsuit. In a nutshell, In a medical malpractice lawsuit, the doctor is assessed by what other members of the medical profession specializing in that field, in that geographic area, would view as the common and appropriate treatment in the circumstances, as compared to what the doctor in fact did perform. The plaintiff has to show, on the balance of probabilities, that the physician breached his duty of care and failed to meet the standards of care required of him or her in the treatment of the patient. That is, that the physician was negligent. Further, the plaintiff also has the burden of establishing, on the balance of probabilities, that there is sufficient causal connection between the negligent act or acts and the injury suffered. And of course, the plaintiff has to prove, on the balance of probabilities, that the damages claimed reasonably flow from the negligent act. A lot of hurdles to cross and climb over. And each one along the way, there's a defense trying to cause the plaintiff to trip. But today's focus is not a discussion on the elements of a medical malpractice lawsuit. Rather, the focus today is on mediating a medical malpractice claim. Mediation, as all of you know, is where an impartial party helps both sides in a dispute negotiate a mutually acceptable resolution. The parties are not required to settle and can return to litigation. However, all mediation sessions are confidential, and what is discussed in mediation is inadmissible if the dispute does go to court. I recognize, coming from Toronto, Ontario, Canada, some of what I say may be unique only to my mediating experience and where I am from, because there is much diversity in substance and style among different mediators and jurisdictions. Nevertheless, I believe there is some commonality to mediations. With that said, I recognize that there are cases where it takes little effort by the mediator to achieve a settlement. The parties come in with the same mindset, and with some little prodding and effort, the mediator gets the case settled. And usually in those instances, the mediator gets undeserved praise. I also recognize that there are those cases where no amount of heroic effort by the mediator and no amount of prodding or innovation by the mediator will lead to a settlement. In those instances, the mediator sometimes receives unwarranted criticism. But there are a chunk of cases where the parties are genuinely desirous of reaching a settlement and are seeking the intervention and guidance of a mediator. It is those instances where the mediator can add value by broaching the opposing discussions. It is a value that can carry forward even when the case does not settle. It may serve as a platform upon which the parties can build going forward. In many respects, mediating a medical malpractice lawsuit is no different from mediating many other types of negligence cases. However, there are factors in a medical malpractice mediation that present challenges, and I would like to address some of those challenges based on my background, particularly when traditional compensatory damages are not attainable or are not adequate. And here is some repetitious stuff, or maybe some overlapping information, but I will say it anyway since I prepared it. At a minimum, mediation, as distinct from trial, offers the parties at least a few of these benefits. The mediation process allows for discourse, as opposed to having to follow a regimen of constraints and the constraints of a question-answer cross-examination regimen and format of a trial. There are no strict dictates that have to be followed, such as the rules of evidence. Mediation allows for an outcome that is in the parties' control and avoids a solution being imposed by a court that will likely be unsatisfactory to at least one party and sometimes to both. It allows for innovative solutions to be arrived at, crafted by the parties, that may not be attainable at trial. Mediation offers the potential for early resolution instead of waiting years for an outcome where each party faces an element of risk of losing and the attendant costs associated with losing. For the plaintiff, in a medical malpractice case, that means the potential of obtaining some early form of redress and perhaps solace, whereas a loss would be tantamount of adding insult to injury. For the defendant, in the medical malpractice context, a loss may mean having to deal with the fallout of staff morale issues arising from the court not accepting the medical staff's evidence. Mediation offers the parties closure and not having to deal with the mental preoccupation that weighs heavy as a lawsuit continues to proceed through the process, not to mention the savings of time, money, and aggravation. In mediation, the lawsuit becomes the subtext. The mediation is not to be used as a format and forum to conduct a mini trial. In mediation, the predominant focus is the dispute. As a result, the conversation has to turn away, as much as it is possible, from the legal elements of the lawsuit to the elements of the dispute. There's not much value in having a prolonged debate on the law or on the nature and quality of the evidence, especially when counsel is spilling all of it in the absence of witnesses. But this is not always easy and not always possible. Sometimes counsel will try to co-opt the mediator to be their advocate. However, having said this, it should nevertheless be always kept in mind that the mediation is being conducted in the shadow of the lawsuit. The mediator must be cognizant of this and be prepared to do some juggling between the goals of the mediation and the objectives of the lawsuit. Let me give you a brief example of what I mean by turning the conversation away from the lawsuit. A number of years ago, I was involved in a case in which an elderly lady was a patient in a long-term care facility who died while in the care of that facility. The elderly lady was the mother of the plaintiff family. In fact, the details of the case escape me now, but for its outcome. The family brought suit for damages, claiming the facility was negligent in the care of the lady. In reality, given the lady's age and infirmity, the range of potential damages were limited. The case presented minimal risk to the defense of a large award being made at trial, although there was that potential of perhaps an award of exemplary damages. What the family really wanted was accountability, an acknowledgement of a wrong. The facility's position, in a nutshell, was that at all material times it acted reasonably in the circumstances and within accepted industry guidelines. It was a hotly contested case that had dragged through the courts for about 4 years, and trial was about 1 year to 2 away, so the parties agreed to mediate. At mediation, however, the plaintiffs put forward initially all of the facility's failings and demanded huge damages, including a claim for punitive damages, which only served to inflame and harden the defense's position. The defense refused to consider any amount for damages, even nominal amount. Although the plaintiffs reduced their demands as the process moved along, the defendants refused to alter theirs, their only concession being agreeing to waive their costs in consideration for the dismissal of the plaintiff's claim. After dancing around with the parties for about 2 hours and struggling to keep them engaged in the process while they each threatened to walk out, the conversation slowly changed. It changed to, what was the legacy the plaintiffs wanted or hoped to see be left by this elderly lady? Now the focus changed, not solely on damages and liability. In the end, this is what the parties agreed to, that the defendant would make an agreed-upon donation to the defendant facility in honor of the deceased lady. In effect, the defendant was paying itself in honor of the plaintiff. To say the least, this was unorthodox and required some finesse to get it done, but it was supported by everyone and represented a win-win situation for all concerned. And as you heard before, tears were flowing. I recognize that that example I just gave is unique, and that no two cases are alike, and that there is no one-size-fits-all formula. Outcomes can be different depending on the actions of the parties, severity of the harm suffered, nature of the circumstances, and the way each person involved deals with the circumstances, physically and psychologically. Where I'm from, if you bring a medical malpractice lawsuit against a medical doctor, you are invariably going to find on the other side the CMPA, Canadian Medical Protective Association. It's not an insurance company. There's no policy of insurance between the CMPA and the member physician. The CMPA describes itself as a mutual defense organization. It was founded in 1901, and in 1913 it was incorporated by an act of Parliament. It's over 100 years old. Most Canadian doctors are members of the CMPA. In 2012, there were approximately 86,000 physician members. The CMPA provides legal defense, liability protection, risk management education for physicians in Canada, and provides compensation for patients and their families proven to have been harmed by negligent clinical care. I highlight the word proven. I may also add that the CMPA's legal defense and indemnity is not confined solely to negligent medical practice. The committee considers each request for coverage and indemnity separately in accordance with its bylaws. And even if indemnity is denied, defense coverage may still be extended for a doctor free of charge. For example, coverage has been extended to punitive damage